an hour or so. Opening comments to just a couple of minutes, and then we can open it up to the wider panel. Yeah?
Sure. Good evening and welcome to the inaugural panel of the India Law Forum 2022, the maiden edition organized under the aegis of the 82nd SKOCH Summit by SKOCH Group here in New Delhi. We discuss taxpayer rights, deciphering the Indian Charter today, an excellent book by Mr. Mukesh Bhutani and Kinshuk Jha, which provides several policy recommendations on a taxpayer charter, its enforceability, and a recognition of the well-recognized certainty rights for taxpayers. It makes recommendations for fiscal policy reforms, including clear administrative guidance in the interpretation of tax laws, and also conducting impact assessments, which are pre and post legislation, and concerted efforts for stakeholder participation. It conducts cross-country analysis and makes recommendations for international best practices, which India can adopt. A brief introduction of one of the co-authors, Mr. Bhutani, is as follows. He's founder and managing partner of BMR Legal Advocates, a boutique law firm with specialization in domestic and international corporate taxation and transfer pricing. He has over 3 decades of experience in advising multinational and Indian conglomerates on a wide range of matters relating to FDI, business reorganization, cross-border tax structuring, and regulatory policy. He's an acknowledged expert with several landmark judgments to his credit. He is deposed as an expert witness on contentious cross-border tax treaties and TP matters in foreign jurisdictions. From the infamous Ricky Martin interrogation to the Kelka Task Force deliberations, depositions before the Parliamentary Committee on Direct Tax, Mr. Bhutani has been a first-hand witness to developments in the field of taxpayer rights and obligations over the past few decades. Kinshuk Jha, Associate Professor, Jindal Global Law School, has co-authored this book with Mr. Bhutani. His work focuses on taxpayer rights, anti-abuse provisions, and digital taxation. While pursuing his LLM and practicing in the areas of transfer pricing and international taxation, he realized his calling for academia. And he's been teaching students domestic and international taxation at JGLS. In the context of taxpayer rights in India, he first published a critical op-ed in The Hindu in 2017. The same year, he was granted a visiting scholarship at the IBFD in Amsterdam. This research stay facilitated his investigation into the subject of taxpayer rights, and the book, Taxpayer Rights, Deciphering the Indian Charter, co-authored with Mr. Bhutani, is the first title of a series that they seek to write together, and they aim to discern solutions to achieve a fair balance between rights and obligations of taxpayers. On the panel today is Mr. Manish Tiwari, Member of Parliament, Lok Sabha, practicing lawyer in the Supreme Court, and the former Federal Minister for Information and Broadcasting for the Government of India. He also serves as the Senior National Spokesperson of the Indian National Congress. He was also member of the Parliamentary Standing Committees on External Affairs, Law and Justice, Defence, and the PDP Bill Committee. He has also served on several other parliamentary committees and has authored the SKOCH LITFest award-winning book 10 Flashpoints 20 Years. Mr. N. Venkatraman is Additional Solicitor General and Senior Advocate, Supreme Court of India. Sri N. Venkatraman has completed 31 years of professional practice in the field of indirect taxes, direct taxes, international taxation, and in the last 10 years has been doing extensive work in constitutional law, various regulatory matters before the TARI, the Competition Commission, and gas and electric matters, negotiations and finalization of commercial disputes, framing and settling contracts and arbitrations besides intellectual property laws, and has been involved in matters of substantial public importance such as Sabarimala, Article 370, and CAA. He was designated as senior in the year 2006 by the Madras High Court. Besides the Honorable Supreme Court, Mr. Venkatraman is appearing before 23 High Courts spread over various states tribunals across state and center, advanced ruling authorities, SEBI, the Securities Appellate Tribunals, and other forums. Mr. Subhash Chandra Garg, former Finance Secretary, Government of India, has also authored the $10 trillion dream. He previously served as advisor, finance and resources to the Chief Minister of Andhra Pradesh and the Power Secretary to the Government of India. He has also served as member of the Central Board of the RBI, SEBI, and LIC, and represented India as governor on the International Fund for Agriculture Development, Executive Director, World Bank for Bangladesh, Bhutan, India, Sri Lanka, and has served on the board for the International Bank for Restructuring and Development, IBRD, the IDA, collectively referred to as the World Bank, the International Finance Corporation, and the Multilateral Investment Guarantee Agency. He's also worked extensively on economic, financial, and fiscal policy and operational issues at the state, national, and global levels. Ms. Rani Singh Nair is former chairperson of the Central Board for Direct Taxes, the CBDT. She joined the Indian Revenue Service in 1979 and has a broad spectrum of experience in leading initiatives in the area of financial management and public expenditure reform, economic policies for development, tax policy formulation, legislation, budget preparation, and conceptualization of e-governance initiatives. She's also held the board of member legislation and computerization at CBDT and Special Secretary to Government of India. In other roles, she served as Director General, the Directorate of Systems, as well as Executive Director of the PFRDA. Mr. Ajay Wadhwa is the President of the Delhi IT/AT Bar Association. Mr. Wadhwa has been an advisor of the taxation study book of the NIRC of ICAI for more than 5 years. He has delivered more than 200 lectures across the country and is currently the president of the IT/AT Bar Association. He has handled cases before the Income Tax Settlement Commission, the Income Tax Appellate Tribunal, and also appears before the Delhi High Court. Mr. Wadhwa specializes in matters relating to search and seizure, structuring of tax affairs of large corporates, matters relating to FEMA, the PMLA, the Black Money Act, and indirect taxation. He is passionate about the rights of taxpayers and has been raising various issues at various forums from time to time. Our moderator for this evening is none other than Ms. Menika Doshi, Managing Editor of Bloomberg Quint. She's a business anchor and has an astounding experience of over 20 years in journalism in the field of financial and business news. She's a Ramnath Goenka awardee for the 2005 and 6 cohort, where she became the first recipient of the Award for Excellence in Journalism. Her career started with TV18 in 1996 as a features reporter, and she moved on to CNBC TV18, where she was the face of Young Turks and co-anchored India Business Hour, serving 19 years and 8 months for the organization before joining Bloomberg Quint as managing director since 2016. May I now please invite Sri Samir Pucha, Chairman, SKOCH, to declare the panel.
Well, thank you very much, Rohan, and welcome to you all. Since this is the inaugural panel for India Law Forum, the first time we are doing it, though this is the 82nd summit, there have been two great learnings and revelations to me while we were organizing this. The first one, of course, is I did not know how many lawyers I knew. Now I know quite a lot. And the second big revelation was how many lawyers know us, practically all of them. So I think it was such a pleasure to put together this India Law Forum. And I'm looking forward to learning from all of you. I'm the most underqualified person on this panel, and I'm really looking forward to learning from you all. Look forward. Menika, if you take over from here.
Thank you very much for the introductions, and welcome to an excellent panel. Some great thoughts that we look forward to in the course of the next 1 hour. The beauty of this topic is that it encompasses both form, substance, and culture within the tax administration of a country. Before I get to some of the core issues that are laid out in the book, let me ask the two authors, Mukesh Bhutani and King Shukcha, to in fact give our audience a quick glimpse of what they sought to do with the book, what they think of India's Taxpayer Rights Charter, and whether they think it will be effective in the task it set out to achieve. Mr. Bhutani.
I was just unmuting. Thanks, Menika, and thanks the SKOCH Group, Rohan, Sameer, for inviting me. First of all, the idea of an Indian taxpayer charter is neither novel nor any significant innovation, considering that several successive committees of the government, starting from Raja Chelaya Committee, talked about the speed at which things should be implemented and how the taxpayers should be respected. So it's one thing to say that taxpayer rights are conventionally practiced, if not enshrined in the tax code, and another thing to try and analyze and study the relationship between tax administration and taxpayers. In my view, taxpayer right balances the authority of the tax administrator and the liberty of the taxpayer, including trying to achieve a delicate balance between the two. Clearly, if you look at the Indian law, for the first time in some shape and form, the taxpayer charter came into effect when Mr. Chidambaram introduced the concept of tax ombudsman. Unfortunately, the ombudsman started looking like more a parking space for retired IRS officers. Rani Singh ma'am, my apologies, but that certainly was my experience. And in some shape and form, when the whole concept of tax ombudsman did not work, we came out with the large taxpayer unit, where we said that at least there is some degree of, large taxpayers should be treated in a particular manner. This is besides the fact that in the 80s and in the 90s, some attempts were made, to have certain classes of taxpayers being greeted, being invited. However, I think the codification of the taxpayer rights, which came in for the first time in 2020 budget, in my view, is a landmark development. What we chose as authors is not to talk about the codification by way of an act in the parliament, but more about what next should be done. I certainly drew a lot of inspiration from experiences that I've had with clients, with large multinational companies. I have spoken about most of those experiences, unless they're confidential and they are not in the public realm. But two experiences that really stand out to me was the 1997 experience when I was representing the famous Puerto Rican star, Ricky Martin, and how he was, treated, if I may use that word, by the tax administrator whilst leaving the country. He left the country, but it took 16 years for the Delhi High Court to pass strictures as to the manner in which he was treated. My other moving experience was the arrest of a fellow colleague, and I use the word fellow because he's a qualified chartered accountant, and I used to be practicing as a chartered accountant until 2010. He happened to be the CFO of a large online company called Make My Trip, and the manner in which he was arrested and what followed thereafter by way of the Delhi High Court judgment, which passed strictures, not just declaring his entire arrest as unconstitutional, but also putting out a right to the taxpayer to pursue claims, civil and criminal liabilities against officials who were responsible for that action. This decision was a landmark decision of 2017, subsequently affirmed by the Supreme Court in 2019 as well. So I just wanted to start off by saying that it's part of it is academic, part of it is what I, as a taxpayer and as a tax lawyer, feel, and part of it is also my experience as well. Thank you, Menika.
All right, Mr. Bhutani, I'm going to hand it over to Dr. Jha. Dr. Jha, I think, the broad question I'd like for you to dwell on while you talk about book is, do you really believe it can be effective? And I think in that will lie some of the recommendations, or at least the key ones that you all have made, and that will become then the fodder of conversation for us over the next 60 minutes or so.
Thank you, Ms. Doshi. So certainly, I believe that what has happened in context of Taxpayer Charter 2020, as Mr. Bhutani also indicated, is a watershed moment for the Indian tax administration and the state of taxpayers over here. But I personally believe that, what we are witnessing is probably a shift from enforcement-based regime to an empowerment-based regime, which probably we are looking at right now, where the taxpayers, they are getting more and more, I would say, if not just legally enforceable rights, some reliefs in some way or the other, which the department is willing to grant in their favor. And as Mr. Bhutani also touched upon, this is not for the first time that it is happening, but definitely it's for the first time that the codification has happened. And if we look into a bit of tax history of India, right, from the time of the first Income Tax Act was introduced in 1860, there have been in bits and pieces some or the other sort of piecemeal advancements when we talk about taxpayer rights in India. And that's where when we talk about the 2020 Charter, it's probably a summation, it's probably one single codified version of whatever has happened so far. And of course, there is a lot of room left over there as well, as far as the improvement possibilities are concerned. But then definitely, when we talk about Taxpayer Charter of 2020, what we have tried to take as a base, as far as our book is concerned, we have analyzed the historical aspects, and we have also tried to look on what could be the way ahead going forward as far as the roadmap suggested in 2020's Charter is concerned.
All right, thank you so much. There are an extensive list of recommendations towards the end of the book. We will not have time to discuss all of them. So what I've tried to do is encompass some of the recommendations into one key question that I'm going to put to all of the panelists starting now. And that effectively goes to the heart of what this tax charter seeks to achieve. Is the design of India's taxation system, and by that I mean from legislation to administration, is it suited to be able to give effect to a tax charter in the manner in which this government has sought to do so? I'm going to start by putting that question first to Subhash Garg. Mr. Garg, can you give us a sense from the point of view of whether the legislation is written with clarity, or the bureaucracy is designed with the ability to administrate effectively, or the litigious nature of the taxman, whether all of these are suited to giving effect to a tax charter in full honesty, or are we just taking some very delicious icing and putting it on a cake that's not very tasty?
So thank you, Manika, and I'm very happy to join this panel. What Mukesh has done is to put together an excellent book, bringing the international practices and everything over there, and brought the subject to the table. But before I come to your specific question, I think let me underline that basic role which and the relationship is the state and the taxpayer has. The state is fundamentally funded by the taxpayers. So whether the present taxpayers who pay taxes or the future taxpayers who will repay the debt which the state takes today by paying taxes in future. So the state is fundamentally dependent on the taxpayers. And therefore, the state and the taxpayer should have a relationship which is fair and dignified. The state should acknowledge that it is funded, it is run, it maintains itself primarily based on what the taxpayers give. And I think that's what is the fundamental aspect of the taxpayers' right, is that all right, the taxpayers will fund the state, but you deal with us in a manner where you make a fair assessment of what is expected to be paid to the state. You make a quicker assessment, not allow the litigations or the assessments to go for very long period of time, and you don't harass. The instances which Mr. Bhutani also brought out also deals with that crucial aspect. This, I think, is a very delicate matter where a balance is very difficult to achieve. But that's what a text charter perhaps can sort of make a good beginning for that. Let me also say that in the ultimate analysis, in the tax side, there are three main sort of tax bases, so to say. One is the value created by businesses when they produce goods and services. The second one is the income when it is generated by either corporates or individuals, households and all, on which the income tax is charged. And third, where the assets are created on which the world charges wealth tax and all, we may not have that kind of system. So this value, income and the wealth or the assets are the fundamental tax basis which establishes the relationship between the government, sovereign or state, whichever you say, and the taxpayers. Mr. Bhutani's book does an excellent work for dealing with the taxpayers' relationship with the state on the income tax side. We have the much bigger and still important relationship on the value added as well as on the asset side. I think if this example or this initiative, which Mr. Bhutani and Jha's book has brought out, is carried forward either by themselves or by others, and then we also develop the taxpayers' rights and obligations for both the value as well as asset, I think this book will serve as a very important sort of torchbearer for a very important delicate relationship, which is very important. So I must compliment them for this great initiative and work. Thank you very much.
Mr. Garg, you're talking about expanding rights and obligations from a few crore people, to almost 100 crore. The moment you go from just income tax to value-added tax, because the taxpayer base expands. But you didn't answer my question. Do you really believe a charter can fix what the system has not been able to fix? And I'm not saying this from a critical point of view, but you made the point, right? The country runs on taxpayer money. Are taxpayers treated that way? Are they treated like a company treats its investors? Or are they treated very differently?
So let us be honest about it. The state is a very unwilling partner in adopting obligations on itself. And whenever the state gives you or specify a taxpayer's rights in the form of either charter or a law, it is, and to be very honest, the chances of that being faithfully implemented are relatively much smaller than what the rightful expectations are. But that society should not leave it at that. Society should work as a good pressure point, as a very well-informed and knowledgeable, demanding society for making that happen. The fact that the the Income Tax Act was amended and this was incorporated in that section 119A, which has been brought out, but it has not been followed up with the guidelines and other instructions, literally make it that this is still still it in works. And that's what, so I would keep the expectations somewhat sober and would wait for all of us to work to see that the tax policy and the taxpayers' rights are evolved and taken forward as the state probably intends rather than what it has done so far.
All right, let me take that to the ASG, Mr. Venkatraman. So the very same question to you as I put to Mr. Garg. Do you believe truly, given the way our taxation system in its entirety is designed, from legislation to administration to litigiousness, can a charter of this nature, however good the intentions behind it, truly be effective? I'm afraid, sir, you're on mute. You'll need to unmute yourself.
Thank you, Sameer, Mr. Rohan. And let me compliment Mukesh Bhai and Kinshuk Jha. It's a wonderful book. Wonderful, I say, because it's a compendium. The subtopics under each category is a classic innovation because it's extremely detailed. If somebody wants to know a broader picture of how tax administration works in India, this can be recommended as a good guiding book. I can vouch for that. It is very good in terms of the pick and the flow and the sequence. So congratulations, and I only wish more people read and benefit out of it. Now, answering your question on the three verticals, you may be surprised with this answer, but that's the reality. Of the three organs under the Constitution, legislature, bureaucracy, executive, and the judiciary, today, the organ which is more proactive towards the assessee is the judiciary. You will be surprised, but that's a fact. 10 years back, it's very difficult for an assessee to get an order in his favor. Now, it is very difficult for a revenue counsel to stand up and impress a court and get an order in his favor. This is a huge shift. So, the pressure point is now the judiciary when it comes to at least tax laws. You can find out, earlier it was 8 out of 10. Revenue used to succeed. Now slowly the number is reducing. So judges are quite pragmatic, very justiciable. This is one thing which is happening now. Two, when it comes to legislature, you amend the law only out of necessity. Income Tax Act has been amended a few thousand times and to get over a few hundred and few thousand judgments. So who is the cause? It can't be the executive every time. Many times it's because innovations of the assessee. So that's the role legislature plays. Now, executive certainly can be a better facilitator. It's an expectation, time-long expectation, I can say. Things are changing a lot and things can change a lot. I have to say that. It can change a lot and it is changing to a great extent because now we can't afford, bureaucrats can't afford to lay back and say courts will take care of their interests. Courts are not taking care of their interests. People are summoned for contempt so easily by courts if you violate a court order. So bureaucracy is also now tuning up to these types of requirements. So this is the broader picture. But when you come to the microscopic details, because I have been in the assessee side for 30 years and a government counsel as an ASG in the last 2 years, having seen both, let me place 2-3 things which is a matter of interest. See, at page 52 of the book, it extracts the charter. And one of the rights is having a just and a fair system is one of the rights. I can tell you something which happened today in the court. You will be surprised that these are all happening now. It's all not because you wrote a charter in 2020. Charter in 2020 only reflects the state of mind and the progress that is happening in the country. It's a reflection point. You should understand it that way. See, we had a huge challenge of 90,000 notices in the last 1 year issued between the old 148 and the new 148A. Supreme Court is yet to release the final order, but it indicated today 10 high courts have passed orders against the government. But it took a very pragmatic approach under Article 142 to say, we will deal all these 148 notices as a notice issued under 148A. And we will allow this to progress only under the new regime. So, being just and fair, if somebody is trying to be unjust, there is a system which is ready to correct it. That is something happening within the scope or the ambit of the charter. 90,000 notices, it said we will still progress it only under the new law. So order is yet to be released, but it has come. Now this is one part. I'll just take 2 more minutes on the obligation side. On the obligation, the same book quotes the charter. You should be honest, you should be compliant, you should pay it in time. Now, let me make it very clear to the panel and to the people who are listening. 80-85%, there is no issue at all. Things are happening on its own strength. What we are discussing is about 10 to 15% of issues, okay, in tax matters, of which there are serious evasions, very, very deep-rooted, large-scale, premeditated, serious evasions happening in the country. Somebody is exporting some very precious stone, and for 5 years, his bank account doesn't receive even a copper. What do you do with him? Somebody is producing a very, very high-rated tax product, and he purchases something of worth 50 rupees. He masks it with 10 times of re-invoicing under the GST scheme, goes and claims an export refund of 15,000 rupees. A 50 rupee product is claimed as an export refund of 15,000 rupees. 1,000 crores evasion. Now, so when you say obligation, have we matured as a society to be a society which is tax compliant? We don't need GST at all if you are a mature society. What does US do? You have only a retail tax. The last purchase of a mobile phone is taxed. Nothing else is taxed at the anterior stage. Can you afford to do that here in India at this point of time? Nobody will pay tax. Because the last mile retail trade is yet to be completely brought in sync. So there are issues ranging 10 to 15%, where the rights versus the obligation is always a challenge. And resolutions happen in the judicial forum. Bureaucracy can move forward a little more, and they are. But more importantly, evasive-prone industries and evasion-prone assessees, which out of this 15% are a significant number. You won't believe the kind of income tax violations, because I'm seeing this now in the government side. There are 4 or 5 important centers from where very methodical evasions are happening. Manipulations are happening. So how do we, when you write a book on the charter, we should also now author a book on these aspects, educate them. How do you bring it up together? Then this charter will be a fulfilling success at some point of time. Namaste.
Right. Thank you, Mr. Venkatraman. Manish Tiwari, I don't know whether to find hope in the ASG's comments that the judiciary has been trying to correct the balance, or to despair. We do know that given our judicial infrastructure, it takes years for cases to come to fruition. That's number one, but that's a well-known thing. I do want to point out 2 other things. Before you appeal orders, whether at the tribunal level or higher up, you have to pay at least 1/5 of the amount demanded by the taxman. That is already a punishment on the assessee. And then finally, I do want to point out to one fact that even the ASG pointed out too, which is that despite a terrible rate of success at winning cases, the tax department's litigiousness has not declined in any fashion whatsoever. Pre-pandemic, the data suggested that at the ITAT level, the tax department success rate was 27%. This was from the economic survey of 2017-18. At the High Court level, it was 13%, so they won only 13% of cases. And at the Supreme Court level, it was a shade better than that at 27%. So if we're going to wait for the judiciary to restore those rights, then what does the charter really seek to achieve? And this goes to the very heart of how do we make a charter of this nature effective? Hence, I put this question to you.
Thank you very much for those very profound questions. But before I commence answering them, let me congratulate both the authors, Mr. Mukesh Bhutani and Mr. Kinshut Jha, for putting together an extremely erudite book, which not only spans across the evolution of the tax code, but more importantly, even flags best practices around the world, which possibly need to be emulated. And so therefore, this is a very important volume to the entire to the writings on tax jurisprudence in the country. And may I compliment Mukesh and his co-author for actually doing a very seminal piece of work. Well, to answer your question, I would like to step back a little.
Okay.
Look, the taxpayers' rights, or the Charter on Taxpayers' Rights, if I may use that terminology is unfortunately, for the lack of a better word, again a headline hunting exercise. So therefore, during a budget speech, you need to say certain things which are pleasant also. And so therefore, this is the more pleasant part of the budget speech, which the finance minister tries to make in order to lace over some of the more unpleasant parts of the budget. You see, fundamentally, let us understand that till the time you don't have a mindset change in your tax administrators, any charter that you may put on the statute or you may put in the public domain is frankly not worth the paper it is written. And whether you like it or not, our tax administrators are still in that colonial Lagan mindset. And I use those words very responsibly, colonial Lagan mindset, where they believe that they are actually collecting Lagan on behalf of the state. Let me tell you, when I used to represent a far more urban industrial center as a member of parliament, I represent a predominantly rural constituency now. There are horror stories of how assessees, and both on the direct tax side and the indirect tax side, were actually made to cough up disclosures at pistol point. I've had the occasion of actually flagging some of these aberrations for the consideration of successive finance ministers and even successive chairpersons of the Central Board of Direct Taxes, one of whom happened to be a very illustrious relative of mine. So therefore, there is a fundamental mindset problem which still continues to perpetuate itself today. You see, and this is a mindset problem which goes across the entire government space. If you were to take into consideration a recent Parliament question of mine with regard to how the Enforcement Directorate behaves, and I'm digressing a little, if you look at the number of raids and searches and seizures that they have carried out, qua their conviction rate, it's absolutely laughable. I think they have an abysmal conviction rate of 2 to 3%, and this is according to the answer which they gave Parliament, and this is perhaps at the trial stage only. So till the time you do not have a fundamental reform in the manner in which tax administrators are trained, unfortunately, whatever statute or whatever taxpayers charter you may put on the statute, it is not going to work in practice. Number two, and when I was in government, I used to keep articulating it even at that point in time. You see, this whole business of fixing targets for tax ranges, that this is your target and you must collect and deliver on it. I think this is completely a self-defeating exercise, because then your assessing officers actually pass on those targets to various chartered accountants who then try and coerce their own clients in order to cough up tax. And then if they're not successful, the tender mercies of the investigating wings are let loose on them. So therefore, the manner in which we go about administering this regime there's a fundamental flaw in it. For example, now you've introduced the scheme of faceless assessments. And I had raised it even in the Standing Committee of Finance when all the tax administrators had come to depose before us. And I said that, this seems to be a completely airy-fairy, counterproductive kind of fishing expedition that you have undertaken, primarily because, notwithstanding the aberrations, there was a certain understanding of the business imperatives between an assessee and the entity which was being assessed. So therefore, there was a previous track record which could be referred to. There may have been previous appearances which the tax administrator at the assessing officer's level would possibly have in his institutional memory. Now, when you introduce this entire conception of faceless taxation, right, you actually have people who are paying a arm and a limb to actually find out as to, who are the guys before whom a particular assessment is going. And so therefore you've just raised the entire bar and the cost for the assessee. And so I think fundamentally, you have to reform and re-educate your tax administration system. And number two, till the time you don't widen your tax base, and that's more of a political problem than any other problem, you cannot have the entire progress and the development of this country being financed by 3 or 4% of the people. And of course, a certain X level of corporate income tax which may come in. So till the time you do not fundamentally rethink this equation, whenever this question is raised in Parliament, you have, numbers trotted out saying that from 2 crore assessees, we've gone up to 4 crore assessees. But the fact is that most of them are zero filing assessees. So in reality, there hasn't been a quantum change. So some of these very fundamental postulates that, as the first speaker was alluding to, that the taxpayer finances the entire functioning of government. But how long can, on such a narrow tax base, would you actually continue down this path? If at all you have some aspirations of converting India into a $5 trillion or a $10 trillion economy, I mean, if those are what your objectives and aspirations are. And so I think while Mukesh and his co-author have really tried to at least put this in the public domain, how many taxpayers are really aware that they have rights? But till the time I didn't read Mukesh's book, I wasn't aware that I had any rights. And though at some point in time in my life, I've been senior standing counsel of the revenue, right? So therefore, I think there's a need for assessee education. There's a need for a wider proliferation of information. And more importantly, then there has to be a culture of adherence to what the government professes. I'm sorry if I've taken too much of your time, but I leave it at that. Thanks.
Oh, thank you very much, Mr. Tiwari. I'm going to take many of these issues raised to the one woman who bears the burden of, in some ways, defending the department on this panel discussion. Ms. Rani Nair, I don't mean to make you answerable for many of these issues, but maybe you can give us better insight, because it's not just about mindset. As recently as a few months ago, it was also about infrastructure. We're sitting here discussing and celebrating a book that talks about taxpayer charter, taxpayer rights, and taxpayer obligations. And just a few months ago, we had taxpayers up in arms because an income tax portal was not functioning, leading to great inconvenience. This is as basic as it could get. And here we're trying to speak of, fairly sophisticated rights and the enforceability of them and what to do in a digital age. So explain to me, ma'am, how is this charter going to be meaningful in the lives of people like me who are hopeful that there is some respect to be paid for being a taxpayer?
Thank you, Venkat. And I would like to congratulate both Mukesh and Kinshuk for writing a very detailed and I think it's one of the rare books where taxpayer rights and obligations have been discussed. So it will be one of the books which many people will read and then go forward from there. Let me say that, the income tax department is always maligned. People are very unhappy with it. And in my mind, I think of the income tax department like a dentist. When you go to a dentist, you hate him. So we extract money from your hard-earned endeavors and you don't like it. But somewhere, if you step back and look at it, for the last 20 years odd, Income Tax Department has been trying to change itself. It is evolving with technology. And today, about 97% of an ordinary taxpayer has no problems with the department because they file their returns online, they get their refunds online, they can have a grievance online. So there are a lot of initiatives which have been done. You mentioned that last year the returns filing was not possible because of glitches in the system. But with all fairness, the glitches were not on part of the department. It was a technology failure because we were trying to upgrade our systems. And because of that, the service provider could not, provide the quality of service we want. So these glitches happen when you convert or you upgrade technology, and it is not a normal thing that happens. Today, technology has helped the income tax department from reinventing itself. You see, when we started our career in 79 or even before, it was an enforcement-enabled tax administration. You told the taxpayer, you have to pay this, you have to file the return. It was from the departments, they were diktats. Then came on voluntary compliance. We tried to make the tax laws easier. We tried to make e-filing universal. So, it became a voluntary compliance, trying to encourage people to. Today, I would say that it is cooperative compliance. We are gathering information about the taxpayer and we are sharing it with you in our annual information reports, in our 26 AS. So when you file your return, you are not thrown a googly, a surprise that, oh, I am getting a notice for some interest which I did not include in my return. Today you can see yourself and then file a return which is more in line with what the department expects you to. So we are trying to make things easier for the taxpayer. As far as taxpayers' rights are concerned, I am 100% for the department giving the taxpayers every right. In fact, if I look at it, what are these rights? They are the duties of the department to treat a person with respect, to have certainty and clarity in the laws, to pay the refunds in time, to resort to grievance resolution. These are our duties. The taxpayer doesn't need a right because we should be giving it. Where if we have failed, we should put corrective actions. If you look at the book on page 99 and I think 271, there are a list of best practices globally. Those best practices, India can tick most of the boxes. You have ticked most of the boxes. So if we have so many best practices and yet you are unhappy with the department, there is something wrong with what we are doing. And then I come to the second part of it. It is that 3% of the taxpayers, which even Mr. Venkataraman mentioned, that 85% are good and 50% are tax evaders. So they are the ones where problems arise because we need to put in systems for better tax reporting, for weeding out evasion, and ensuring that the taxpayers are compliant. The aberrations in the behavior of a tax department, whether it is a Ricky Martin case, whether it's Make My India, whether it's during the search, the enforcement functions, those are things where we need very strong taxpayer rights, which should be enforceable, so that if there is a genuine case of overreach by the government, by the tax department or any other department, the ordinary citizen of this country, taxpayer or even a citizen, has a recourse to a legal remedy. So I would say when we talk of taxpayer rights, maybe we need to expand it to the citizens' rights. It is not only vis-a-vis the department, it's a vis-a-vis with a host of other government agencies that we must, as a citizen, have rights. And those rights, if we have, then of course the taxpayers' rights will also be.
Okay, fair enough. And then by that extension, we should also include obligations on citizens to pay taxes it does fix the problem then of a smaller tax base to some extent. Mr. Wadhwa, I think, the final question to you before I go back to the authors to outline some of the key recommendations they made in the book, because there are over 25 recommendations. My question to you is, this is a lovely conversation to have, and it's meaningless also because these are not legally enforceable rights. It's a great charter. It's a one-page charter. It's simply told. But I really can't go to a court of law and say, the tax department promised me certainty under this charter, and therefore I, deserve this kind of treatment. So, I don't necessarily maybe have great legislation in terms of clarity or intent, may not have, the best of infrastructure at all times. Maybe the mindset suffers, and I don't even have enforceable rights.
Thank you, Manaka. Heartiest congratulations, Mukesh and Mr. Kinchuk, for such a wonderful book. The book very succinctly delineates the problems, and very often we come across books of a similar nature where problem is mostly highlighted. But you've ended the book with a 20 Sutri Karikram, the 20 policy changes, which are very telling. And I tell you, if they are strictly adhered to, you will the wish could turn very true with the problems evaporating in no time. But I'll get your main question. But I have the advantage of hearing a lot of experts, and therefore I just like to dwell on what the essence is, because there is a little bit of a difference between me and all the other eminent
Please do.
experts that you have on the panel today. See, I have been, like Mukesh, in practice as a chartered accountant for a very long part of my career, starting 1986 to 2012, 2010. In 2010, like Mukesh, I turned into a lawyer. So I have the flavor of going right down to what happens at the grassroots and what is happening now. So let me tell you a little bit. Am I audible?
Very faintly so, Mr.
Well,
Wadhwa. Unfortunately, I think your connection is not very strong. So your audio is way.
I'm sorry, is it better now?
Somewhat.
Is it better now?
Somewhat, I might say.
It only had to happen now when I was about to speak.
Well, my apologies, then I should have come to you earlier. I had no idea your connection would fail my timing. So I'm sorry for that. Would it help if you switched off your video and that would allow us to at least hear you more clearly?
I'm sorry. Is it okay now?
I think this should be okay. If we don't hear you clearly, we might ask you to repeat yourself.
My apologies. So I said, there used to be a time, not very long ago, when we didn't have the faceless assessments.
Yes.
And this used to be a common complaint of all the people representing before the income tax department. And, the tax used to be collected more out of harassment than the execution of the law. You go out, sit out, wait hours together in 42 degrees, no water. And then after 3 hours, you go to the income tax officer. And by that time, you say, well, I'm willing to surrender and do whatever you wish to. So there's a paradigm shift post that.
Yeah.
And I must tell you that the shift is, I'm personally very enthused with what has happened now. And now I think is the time to really enforce the charter, and it is enforceable now.
Okay.
Now imagine, and I think it is also this faceless and this IT-driven assessments and appeals. These are all now a reality. One cannot wish them away, and one should not wish them away. And also, if the statistics are to be seen, ever since faceless has been introduced, the revenues have never been more buoyant. Probably this year, there is the highest collection on income tax. So therefore, this vindicates the stand of the government that the old procedure whereby people would sit out, have a one-to-one meeting with the assessing officer and sort out the tax matters was not as effective as it is now. Now, coming to your point, you said about the charter. Now, the charter, whether it is enforceable. Yes, it is enforceable. Let me give you an example. Recently came across a Bombay High Court judgment where this is in the case of Tata Projects Limited. It's a very recent judgment where the refund was not being granted to the assessee for a very long time, which is a very common problem even now. So the matter went up to the High Court. And in the High Court, there are two of the judgments, a brief judgment. The petitioner cited a photocopy of the Citizens' Charter, saying, which is a declaration of our commitment to the taxpayer, where they say refund has to be given within a short period of time. So they cited that. They held the department responsible based on the charter and said, why the money in terms of interest should not be recovered from the officer? Get back. This is empowerment. And how can this happen? This can only happen through technology. And this is what is happening. Now, coming to the other aspect on the enforceability. Now, it has become a part of a section in the statute. It's a part of section 119A of the Income Tax Act. So what happens? Whenever you have something on the statute, you seek to get it enforced one way or the other. And that's up to us to get it enforced. At least now you have the platform to get it enforced. And I must also tell you, my colleagues in the office were looking into what they have done post the declaration of the charter. The Principal Chief Commissioner of Income Tax Gujarat, while his notice dated 13/5/2021, has brought out detailed guidelines how this charter is to be enforced. In fact, he even posted 10 officers who are going to enforce the charter. Same is the case with Principal Chief Commissioner Chandigarh, and I'm sure others are going to follow suit as well. So the point that I'm trying to make is, yes, the problem subsists, and the problem subsists, it stares into our face. Absolutely, it does, because look at the statistics, look at the numbers. You've got 92,000 cases pending in the ITAT, 38,500 cases pending in the Supreme Court, 6,500 cases pending in the, 38 in the High Court and 6,500 in the Supreme Court. 4.6 lakhs tax arrears are still in litigation. This speaks volumes of how the administration is, and they need to really back up. So the point that I'm trying to make is that the faceless regime which has now started, it had its problems. Those are teething problems, I would say. But they also give a handle to the income tax department, much easier income handle, rather than managing people who are sitting face to face, interacting with the assessee, saying all kinds of things, doing all kinds of things. Now you drive it by technology. Now the face. Now see, that's what I'm saying. What we need to discuss, what we are discussing today, is the interface of the assessee with the department in respect of three of its wings. And what is the interface? One, when you file the return of income. Now that's become seamless. Two, when you are assessed, there also you don't get to see the officer. Three, when you go into an appeal, there also you don't get to see an officer. Well, what are the checks and balances? So in an assessment, what is supposed to happen? I'm supposed to file my details. Now what the department ought to do is rationalize, standardize the manner in which a questionnaire needs to be asked. Don't ask 1,000 queries. Standardize. That's it. And this they can do now that it's all technology driven. Two, the department has to make sure that the reports from the department, from their officers, come in time, which they can again do now. Three, they have to give a show cause notice, which they were never giving, which they will now enforce because it's all technology driven. Then a virtual hearing. So the courts have come down heavily and said, yes, principle of natural justice must be adhered to. So give virtual hearing. All these things are possible because you are now technology driven. You are not meeting a person face to face. You can standardize a lot of your procedures and systems, make sure those standardized procedures are followed, rather than depending on the whims and fancies of officers. You see, every human being is a world in himself. You go to one officer, he doesn't understand this problem. He has an ego issue. Those kind of things used to plague us day in, day out. No, that's history. So my view is, I feel that the charter has come in at a very apt time. It has been brought into the statute. It has given us, empowered us to have it enforced. The courts, as I already told you, Bombay High Court has already relied on it, and many courts are going to rely on it. And this is something which empowers both the department as well as the assessees to try and enforce it. Of course, it is omnibus, it is a single line, it is subject to interpretation, but it gives out the intent.
Yeah, no, I understand that. And that's what I meant by enforceability. I didn't mean that it was not part of the statute, but what I meant is the specific promises that it seeks to make. Can those be enforced in individuality? But I get your broad point, and you've made a hopeful point. Though I must say, Mr. Wadhwa, I hear rather contrasting reports on the success or effectiveness of faceless assessments. We won't go down that rabbit hole, because people come to journalists mostly to complain. So maybe I'm only hearing a narrow voice. I want to take it back to both the authors for some very quick highlights of the recommendations that they've made on how to make this charter more effective. And then I'll come back to the panel to identify what they think the priority area should be, because we have about 15 or 20 minutes left in this conversation. I want to use it to sort of leave audiences on a forward-thinking note. So, Kingshuk, let's start with you first before I go to Mr. Bhutani. A couple of the key recommendations that you have made towards the end of your book, in terms of being able to enforce better, which I've already touched upon, but some of the other ones.
All right. Well, on the enforceability bit also, I would just make a quick comment. And since Mr. Wadhwa was just speaking about it, in India, we do not have a proper structure when it comes to enforceability of Taxpayer Charter 2020 yet. But that's not stopping us short from implementing it properly. And the reason behind it is, if we take the example of US TABOR, the Taxpayer Bill of Rights, even that's a legislation which was brought into, or you could say it was a codification which was brought into effect, minus the administrative mechanism behind it. And it was interpreted that while TABOR does not create any new set of rights in favor of taxpayers, it can be very well interpreted with the existing protections which are there. And this is pretty much similar to what Mr. Wadhwa just mentioned, that different ITATs across the country, they are already trying to align the taxpayer charter with certain guidelines which may be existing, or they are trying to frame their own guidelines. And this is pretty different from the approach which another jurisdiction has in this slide, that is of Australia, where along with their taxpayer charter, they have a proper administrative mechanism which they have brought into place to enforce or to ensure the enforceability of it. So what I'm trying to indicate is, while the approaches of different jurisdictions may be different, but at the same time, the constitutional framework which we have, the administrative law framework which we have, it can still be read with the charter, or the charter can be read within the scope of these protections which we already have, and therefore they can be a protection framework which can be created for a taxpayers. Now, that aside, one of the major recommendations personally which I would like to touch upon is the idea of increased stakeholder consultation. Now, this is an idea which has been pending right from the time of it was first recommended by Dr. Shom in TAC committee recommendations of 2014, and no concrete step has been taken in this direction. A burning example which I can give in this context is that of equalization levy of 2020. The manner in which it was implemented, there was no stakeholder consultation. In fact, the equalization levy 2020 was not even included in the finance bill. It came as a surprise to the industry, and most of the clarifications, they arrived a year later. So these sort of practices, as we go forward, they are also within the broader framework of taxpayer rights, their protection, and the point which I mentioned, that from enforceability to empowerment, this is how we could empower our taxpayers by actually including them in the legislation making process. Instead of just having a reactionary set of comments from them, they are involved in the process right from the beginning. That could be a major turnaround which we can achieve.
It's an excellent point, because we saw that in terms of the blowback to the digital asset taxation in this year's budget. And I don't think anybody can deny that crypto assets should be taxed. But I think it came so suddenly, and it came at such a high rate that the entire reaction was negative, right? This goes to the root of certainty. And whilst this government, Mr. Bhutani, has done great things, including the repeal of the Retrospective Act, from 12 years ago, we still aspire for certainty in our tax administration, in our tax legislation, don't we?
Melika, is that a question for me?
Yeah, that's a question to you, sir.
Okay, well, I just want to make one observation before I answer your question, which is that to me, listening to this panel seemed like cornering Mrs. Rani Singh Nair. The book is not
my intention at all.
Yeah, I actually have made wide references to some of the reformative measures in the book. Those may be outlier situations, but Mrs. Nair certainly comes in that outlier situation. Most people forget about his committee's recommendations when the then finance minister decided not to appeal against the Bombay High Court order in what seemed, in his view at that point in time, could be a nuisance value from a public interest litigation standpoint. And I know that he carried this matter to the cabinet to take that decision. There have been many instances in the past where such reformative measures have been taken, though with a degree of inconsistency. Our book captures all of those instances. On the recommendation, Menika, coming to your question, there are many recommendations, but I'd like to highlight 2-3 of those recommendations. One is seeking legal enforceability of what we term as a right under the Constitution, which would be, so it is certainly a legal right under the Income Tax Act. And our Constitution, given the richness of the jurisprudence that we have, and Mr. Venkatraman will bear with me, has expanded the fundamental rights now to 30 forms of fundamental rights. And I just hope that we don't have to wait for the Supreme Court one day to say the taxpayer charter or a taxpayer right is indeed a fundamental right. I think in spirit, we should start enforcing it as a fundamental right, despite the fact that there is no mention in the Constitution and there is mention only in the tax code. The second aspect is the principle that you alluded upon, which is the principle of certainty. The principle of certainty, again, is something, it can't be just stated in the charter, it needs to be seen as being practiced. The retrospectivity part is something that categorical statements have been made. However, consecutive amendment to the budget do not give that degree of confidence that certainty is at the core of the charter. So I think there should be something more that we would like to see on the certainty front as well. I also feel that the time has come to be very specific in the charter about service standards. And what I mean by saying service standards, I mean by saying that there is, even within the administration, a gap between the manner in which the policymakers think about a policy and how it actually gets implemented. So one thing is to say that there is a gap, but I think if the charter takes forward the exercise with specific service standards, I think it will make a lot of difference. The last point I wanted to make was on accountability. And when I talk about accountability, I don't mean to say accountability at the field level, but accountability to the parliament. So there is nothing stated in the charter, unlike the charter in the UK or unlike the charter in the United States, which talked about a recognition and a mandate to issue periodic reports, which are actually published as a part of taxpayer services. I'd like to see that. I'd like the pensioners in this country to know about how many times and how many pensioners were not given refunds on time. So it's not just about large taxpayers. It's not just about the kind of clients that we work with, but with everyone. So I think the charter has to recognize and mandate periodic reports, and which should be published, and actually it should be tabled in the parliament to build in greater accountability. So those are some of the recommendations I wanted to highlight.
Thank you for that, Mr. Bhatani. Mr. Garg, I don't want for citizens to or taxpayers to have to rely on the judiciary to enforce their rights, because that is a very arduous process in this country. So let's talk about what can be fixed on a priority basis and easily, but not on a cosmetic basis, at the administration level itself, because that's where it really needs to be fixed, right? Mr. Bhatani speaks about accountability. I want to know, do tax officers if they indulge in frivolous litigation. And by frivolous, I mean they know previous cases have gone against in that principle, and yet they continue to, despite this dismal success ratio. Are they held accountable in any fashion? Sir, you're on mute.
So this question is addressed to me. So fair enough. I think
I'm just using it as an example of accountability.
Yes, fair enough. So see, in the taxpayer implements the taxation law to get the tax for the government. That's the fundamental aspect of it. And therefore, if the tax law itself is not very clearly defined, it's not in a very certain, you mentioned about the crypto taxation which has been introduced. So it introduces a lot of clarity, but at the same time, a lot of complications as well. So whoever will be administering this tax will create problems for the taxpayer. The retrospective taxation or the charitable institutions related taxation. There's so many aspects of our tax laws which any tax administration will find it very, very difficult to administer. And then they sometimes tend to misuse that for their personal gain as well. So if we want tax administrators to be efficient, considerate, and at the same time dispose things very well in a manner which is sort of respectful to the taxpayers, I think number one thing which we need to do is to get a tax law which is very simple, which is very clear. And in that respect, I don't see in the indirect taxation, we moved away from the system of taxation or assessment based on what is the value created, etc. We accept the invoice value as something which is acceptable to the department now. Right. I don't know why we can't accept for the businesses. And I'm saying this because business is ultimately the source of all the tax which comes to, whether it's the corporate tax or the income tax, which is the income which is derived from the business and all. Can we move to a system where we align the books of the businesses with this digital age now, with everything coming on board, to the taxation law, rather than having two different kind of regime where tax people or tax law believe that there is something which is not allowable, which is allowable, or which has to be given weighted, and also do away with the exemptions which are there. Can we bring that kind of very simple tax administration? And I think if we can do that, then the tax administrator would also be empathetic and simpler and make the life easier. We can go on, but in view of the time constraint, I think I would like to say that the tax administrator also deserves either his rights or whichever way to get a tax law which is very simple, very easy to administer, doesn't leave him with a lot of complications, etc. to do with it. Thank you.
And then you pass the buck on to Mr. Tiwari as a member of parliament, and I'm going to therefore ask him to speak on behalf of lawmakers in this country. Mr. Tiwari, that goes to the very heart of tax administration, the design of law, and the lack of clarity. And we're not talking about extreme cases of retrospective, levy of tax. We're just talking about, generally speaking, poorly written laws.
Well, I entirely agree with you. Not only are laws poorly written, but they are very poorly debated in Parliament also. So therefore, that's actually a double whammy. And I think there is a very strong case for having a new direct tax code. In fact, during the debate on the budget, both in the Lok Sabha and in the Rajya Sabha, various people have alluded to the fact that there's a need to rationalize by enacting a new statute, the Income Tax Act of 1960. And so therefore, that's a call which the government would have to take. But then going by certain previous experiences, for example, we overhauled the Companies Act in 2013, and look at the number of amendments that we've had to do to the Companies Act between 2013 and now. The Insolvency and Bankruptcy Code, is another classical example of where we do amendment after amendment. I think every second month there is something before the second Standing Committee of Finance in terms of an amendment which has been brought to the IBC code. So I guess there is a problem of not thinking our statutes through, and then rather than letting them get interpreted by judicial precedent, which would be the correct way of doing it, you try and sort of do it by one amendment after the other, which then ends up creating a code, which is, for the lack of a better word, a mystery wrapped in an enigma, encompassed in an envelope. And this whole crypto business is a classical example of government having not thought through exactly what it wants to do. So on one hand, you have taxed crypto assets. On the other hand, you are saying that, we've taxed it, but it is still illegal. So therefore, in the tax form, are you going to tax crypto income as income from undisclosed sources? Number two, you have not regulated the exchanges. There is no regulatory architecture on the exchanges, right? The TDS component that you have levied is actually driving the entire business away from Indian exchanges to foreign exchanges. And even if, let's suppose tomorrow, you were to put some kind of a legal architecture onto cryptocurrency asset, whatever you would like to call it, till that time, you have no regulation mechanism at all. I mean, how would you even get to know that if I have traded and earned something out of a crypto asset? And then again, by not allowing an offset, that, all right, your income will be taxed, but whatever you lose, that goes to your account. It actually defies logic. And so therefore, I think there is a lot of thinking required on these issues. And partly the problem is, and I don't want to, again, be the naysayer all the time, but I guess a part of our problem in our governance system is that any legislation, be it tax legislation or be any other legislation, it is bureaucracy driven. It is incubated by the bureaucracy. There is hardly any stakeholder consultation. In fact, there is a policy of stakeholder consultation which has been on the statute since 2014, or it's been in the public space, but government does not follow any stakeholder consultation or does not do any stakeholder consultation at all. And then finally, when it comes to parliament, every legislation is subjected to whip-driven tyranny. So therefore, neither do you have the flexibility of voting according to your conscience, common sense, or constituency. If you sit on the treasury benches, by rote, you will vote for a bill. If you're on the opposition benches, by rote, because a whip is issued, you will vote against the bill. And so therefore, even government ministers do not walk the extra mile in order to take the concerns of even their own members on the treasury benches on board. There was a time before this whole anti-defection law was enacted, and which has taken democracy out of your legislative institutions, when ministers used to walk the extra mile to build consensus on legislation, because more often than not, bills used to get voted on or against by members of the treasury benches also. So there is a fundamental problem in our entire legislative system. It's become completely dysfunctional. And till the time you do not fix some of these issues, to expect Parliament to make better laws is, I think, asking for the inconceivable. And when you go down to the state level, it is much worse. Your legislatures maybe meet for 10 days in 365 days.
Yes, I think PRS record shows.
That's the reason. If you look at the PRS record,
4 days or something like that.
In Punjab, I think the Vidhan Sabha has not met for more than 10 days in a year for at least the last 10 years. I mean, Kerala and maybe Tamil Nadu are much better in that respect. So therefore, there is a fundamental problem that we have in our legislative system, which is creating a situation whereby you have the Chief Justice of India on record saying that, when you have legislation before us or the constitutionality is challenged, there is hardly any debate which we can go by in order to figure out legislative intent if he's right. So I think some of these larger issues need to be fixed, but I take that point that you need a leaner, meaner, slimmer direct tax code, and which of course you don't amend every 6 months after that.
Okay, no promises on amendments, and one insurmountable problem at a time, tax system, then legislative system. Mr. Venkatraman, I want to twist the phrase insult to injury and say injury to insult, because not only do we have a problem with lack of consultation or poorly designed laws or not enough debate, but we also do have, over the last several years, the granting of indiscriminate powers of arrest or otherwise through some of these laws that go against the very grain of what this charter seeks to do. And this problem doesn't necessarily lie at the tax department's feet only. It lies in the way we're empowering departments, right? We've had instance after instance. Mr. Bhutani has narrated the Make My Trip instance in his book. There has been another instance in the case of the Swiggy situation in 2019, where the management was arrested and paid up 15 crores in GST at 4 a.m. in the morning in the GST office. And some concocted story about, which was completely thrown out of court, about the tax officer shut the door and therefore the management could not leave and was able to leave only the next morning. Why was any management or taxpayer in any tax office at 4 a.m. in the morning, right? So I'm just wondering, I love that we have a charter finally. I just have very little hope that it will deliver effective resolution to us if we are not able to fix all these very fundamental structural issues.
Before I address this, one or two legal course corrections as a responsible law officer, I need to make it. The statement that this was just a budget proclamation or a budget show and nothing beyond that is factually and legally not right, because this code has transformed itself into a provision called Section 119E. It's a clarification. Two, the desire of Mukesh Bhai that this should become a fundamental right, it can only be a desire or a dream. It cannot become a fundamental right because these are all statutory rights. Let's understand the difference very, very clearly and candidly. And you must read the judgment of the Supreme Court on cryptocurrency. It has discussed a 185-page judgment discussing how crypto operates all over the world and what are the governing laws and how people are still, the whole world is very tentative about this. Let's understand it very clearly. One should read the judgment to make up their mind what crypto means. It's a classic collection of the world practices. And when we find money coming into India, legal or illegal, when you say 30,000 crores is coming, 50,000 crores, whatever is the number, what's the harm in taxing it? Is the question in crypto. Writs have been filed and we will defend it in the courts. 4, technology has enhanced more number of assessees to log in to become tax assessees. In GST, prior to technology, prior to the transformation in this platform, there were 60 lakh assessees. And now we have crossed more than 1 crore. And the tax collections are almost touching 1.5 lakh crores, which you could not have got it earlier. So it's not simply buoyancy, it is tax compliance. And unless you have some fairness somewhere, this compliance to this level we could not have reached this. So let's give whatever is due there. 4. Now, answering your question on arrest. Before that, I just want to ask you one question. So you're all talking about fairness, just and treatment. Let me give you an example. When GST came into force, on sheer trust, we said, whatever you can show as your address, we will take that and register. Left, right, and center, we issued registration on pure trust. After 2 years, where did these people lead us into? The
staggering figure of evasion on fake invoices is several thousand crores. Now we have come in the law. So in India, you must understand, see, it's happening there in Singapore. Take the size of Singapore and take the size of India. They are not comparables. India is a large country with large mappings, and different geography territories have different attitudes in tax compliance. I can say this with a sense of responsibility, defending matters across India in the Supreme Court. The attitude from different geographical territories are extremely different. Somebody is aggressive, somebody is belligerent, somebody is compliant. It all happens, as a matter of fact, statistically. Now it's so big, you have to organize yourself in the best way possible. And a golden mean is achieved, and it is progressing in its own way. So it will take time. You can't, a fit size all is not going to work in India because of this size, sheer size. So it will take some time. Now, unless there is the concept of breach, as it keeps diminishing, take it from me, Menaka. This is the formula for code. As the concept of breach diminishes, the development of trust will get enhanced. They have to work together. You can't pick one and leave the other and say you're not following this now. This is one day or the other. The administrative jurisprudence across the world is an evolving science. It evolves much faster than constitutional law. So administrative law today has traveled so far. So one day, what is empowerment, what is enforcement, all these will get decided in one way, and it will improve efficiency in tax administration. You wait and watch. See, for 60 years, we have carried a legacy. In 1 year, you say we brought a code and tomorrow you have to show progress. You have to wait. There is a time period, and it will change. And last question on arrest. I'll only put two. I'm not defending Swiggy or defending what Mukesh Bhai has seen. There are extreme cases. But take the list of people who have been arrested. Without basis, how many? And with basis, how many? I want a statistics. We have put this across in every court, and every assessee has failed. So there are excesses. I'm not denying. Now you are talking of Swiggy. I'm giving you a case in the same Bangalore, fighting now. 15 devices we have seized. And the fellow says, the man who's asked to give a statement says, I have forgotten, his phones are seized. He says, I have forgotten the passcode. What do you do with him? Should we arrest him or not arrest him? I just want to know. So you can pick some, we can pick some. It's possible. Examples, everybody can give examples, everybody can give illustrations. But I can make you one assurance. I'm not saying there are not excesses. But at the same time, it's not that everybody is arrested left, right, and center. That such a statement is very strong and not correct. It needs to be.
It's not a statement anybody on this panel.
It's somewhere in between the two. That's what I wanted to clarify.
No, fair enough. You're saying obligations before rights. Taxpayers are saying rights before.
It's mutual. I'm not saying one before, one overlooking the other.
Not a new debate at all.
It's like two legs. We have to travel, no? It's like two wheels, two legs. You have to walk together. You can't hop. So if both can walk together, we will reach a very safe destination. Both have to work together. That's the request I'm making to.
Sure, points well taken. I want to go to Mr. Wadhwa, based on the recommendations that both Kingshuk and Mr. Bhutani highlighted as things to make this charter more effective. Let me get your thoughts, because I do want to give the last word on this panel to Ms. Rani Nair. I feel she's unfairly had to defend things that she should not have had to. So I would like for her to have the last word on this, undisputed, before we close it out, and thank everybody.
So, just one, I just would like to react to what Mr. Venkataraman said when he talked about the 15% of the taxpayers really indulging in unpardonable crimes of income tax. Now, I'll just give you one example. You're aware of this entry business where people give cash and you get a check back. But this entry business has been rampant and for years together. And believe me, it's not rocket science to find out the genesis of how the entry operates, the originates. After all, somewhere the cash would have been deposited. The long arms of the income tax department can reach the source of the entry. Now, why did you allow this entry business to proliferate for years together? Why could you not get to the bottom of it? Why could you not pick up the entry operators who you knew were roaming around with aplomb and freedom? You didn't do that. Now what's happened? Now entry business is something which sends shivers down the spines of most people now. Why has this happened now? Because there is a will, there is a political will. People have been arrested for this. But now at the same time, so what I'm saying is, Mr. Venkataman, that the problem has been that you always have to give some discretion to somebody to administer the law. And whenever you give discretion, it is abused. It's also abused because what the legislature tries to do is to fill up the gaps, the inadequacies of the income tax department by taking away the principle of natural justice. Because if they don't give me an opportunity of hearing, they can do what they want. The courts say, no, the opportunity has to be given. And that's when they fail because their investigative skills are found wanting. Or maybe the desire is not there. Now, at the same time, this is the genesis of the problem. Now, at the same time, look at the mistake, in my view, what this government has done. Wait. When the demonetization came, they came out promptly with the law, which was to last the demonetization year only, which is that if you deposit cash or any unexplained money in your account, even in the current year, even in the year for which you have not filed the return of income, you'll be taxed at 60%. Now it's remained to stay, it stays even till date. Now imagine anybody who wants to come clean or wants to declare income for which he doesn't have a source in the manner in which the income tax department expects him to, he'll have to pay 60% plus other penalties. So what happens? The money remains. The money remains in the system. It remains hidden. It remains in the form of gold. How many searches can you conduct? So what you are doing is, you are coming down hard on all these entry operation business, but at the same time not understanding that in India is not United States of America yet. There is cash which will always remain because a large segment of the population deals in cash. Now, what have you done? You can't buy a watch in excess of 2 lakhs in cash. So what do people do? They go to Dubai. Buy as many watches as you come. You buy them. Business shift. So the point that I'm trying to make is, you have to be practical when you make these laws. Now, coming quickly to what I feel, in order to give impetus to this charter, to give strength to the charter, what ought to be done? They have a grievance mechanism, but I think they need to have a grievance mechanism over a grievance mechanism, because every time you file a grievance, they say the grievance is settled, never to the satisfaction of the assessee. So you need another grievance mechanism to go and say, well, so that is very, very important. That will reinforce the confidence. 2, standardize. Today what happens? I have a complicated return sitting in Delhi. Now it is going to be looked at by somebody in a Mufassil area because the assessment is faceless. That gentleman has never handled a return more than 1 lakh of rupees income. How does he handle these complex returns? So you're going to have problems. So like Mukesh said, teach them, educate them, but at the same time, standardize procedures. After all, over an assessing officer, you have an additional commissioner and a commissioner sitting. So have those standard setup formats where the distribution is curved. That's very important if you want to face the system to succeed. Otherwise, it's a disaster in the making. I must say that.
And this is exactly the feedback, Mr. Wabha, I've gotten from a wide variety of tax experts, including the fact that some of the corruption has become more brazen now because it's faceless. They have your contact information. You have no idea who's assessing you. You cannot complain in any sensible fashion.
Menka,
your cases. But I don't want to use the one-off cases of corruption to paint an entire department.
Exactly.
Amongst all aspects of society.
That's what I was coming to. So
yeah, but I'm saying it is not necessarily made all experiences better. And there are some of these fears. That's all.
So I'll give you another example.
Yeah.
Now, how do you make it more effective? Now, the courts hammered on the department saying, give virtual hearing. The assessing officer also has to give virtual hearing before you pass an order, because after all, how much can you write? It depends on my writing skills, and it also depends on his understanding skills. Maybe if I speak to him, I can speak to him in Hindi, in very simple words, try to explain to him. Now, where you can curb discretion is that when I get a virtual hearing, which is recorded, I should be allowed to use that as an evidence, and so also the department when we go to the higher forums. So that whatever I have stated is captured. And once what I have stated is captured, the assessing officer will feel more responsible to make sure that he passes an order where he considers all my contentions. Do that. Treat it as an evidence. Then, very importantly, what happens, Menaka? The high courts keep deciding on one issue. And they decide over and over and over again. Do you know what's happened recently? One decision in a writ court in the Delhi High Court in the case of Manmohan, where they said notices under 148 issued after 1st April 2000 in the erstwhile law are illegal. So the writ court, the High Court says in a writ, they're illegal. You know, there is not even a clarity yet whether once they have struck down the legislation, the officers down below have to follow it unreservedly. Post their striking down, close to 10,000 people filed their own cases in the writ, went up to the writ, in writ, saying, wondering if the assessing officer will follow the decision. Can you imagine? I mean, this rudimentary concept of law is still not understood. What the CBDT should have said is, the High Court of Delhi has decided all officers will follow that decision. Why should 5,000 people have to file petitions and pay ₹1,00,000 each time to a consultancy? These are things they don't understand. I mean, this is a very basic thing. Then, importantly, you cite a High Court judgment which is binding. Supreme Court says in Kamalakshi and hundreds of other cases it is binding. You have to follow it. Officer doesn't think it is binding. He will skirt past that judgment. He will never even refer to that judgment and pass an order contrary to it. Won't make a whisper of it. Now, that's not to be redressed through courts. It has to be redressed administratively. If I am to tell this to in the grievance cell that this is the High Court judgment, the binding judgment has not been followed, the court, the officer should be hanged for this. Not wait for 20 years to go back to the High Court and say, listen, they haven't followed the judgment. Finally, there are judgments which are accepted by the department of the High Courts. They don't go in appeal, or of the tribunal. No one knows which are those. So, even if there's a judgment which has been accepted by the department, you continue to file appeals. Why would I not know? And finally, one more little thing, since you are asking for suggestions. You know, I'm full of it because I've been doing this day in, day out. So you won't...
Baba, you'll have to make it quick and we'll leave it up to Mr. Bhatt.
Okay, I'll leave it at this.
Part 2 to their book.
Yeah. No, and you know, you are playing a trick, Menaka. You are asking me at the end when everybody is fallen and you're provoking me to no end.
My apologies. I'm not asking you at the end. Actually,
next time around, if it happens, ask me at the very first instance, then I won't speak so much.
But please take 30 seconds. Please take 30 seconds.
Okay, I have 30 seconds. Now, what I'm saying is, now the CBDT. What is the role of the CBDT, and what is the objective? The objective is to collect tax, and as Mukesh has put it very, very well in the very inception, that collect it in the best easy possible manner so that one pays tax fearlessly. What's your role? Your role is to administer, to come down heavily on your officers who do not follow your dictates. So 2 ways. One, whenever there is a legal pronouncement, come out quickly by way of a circular, whether you accept it or you don't accept it. And if you accept it, tell our officers to follow it and put it in the public domain. I should also know about it. And then you have a certain set of administrative circulars. And for faceless, it is so important because if you leave it to the courts to decide that, well, you have to give a virtual hearing and the virtual hearing is given on the last day of the assessment, it loses its meaning and you know what's going to happen. It's all going to come back as a set aside. So the board has to be online. This has to be their primary function, to collect tax seamlessly and painlessly. You have the structures intact, but it can go very, very wrong. Because if, like you said, Menaka, you said there is only one instance, a few instances where people are trying to find out who the officer is and get to him. There'll be many if the board does not have its house in order. If I start to feel insecure that God knows what's going to happen, my submissions may or may not be considered, the citations that I've lied may or may not be followed, then what will I do? I'll try to find my way into the officer once again and subject myself to his discretion. So it's a great scheme. If you want it to succeed, be online, be pragmatic, consult people, and finally now's the time. You see, the income tax department, sorry to say, Mrs. Nair, is not a very happy lot at not being able to see the taxpayer. But chartered accountants and lawyers will be very happy to assist the department. Get lateral entries, get competent people to sit behind the desk, make assessments, make appeals. You have no allegation. So get the experts to do it. Let the department also have a level playing field instead of the legislature keep arming them with the draconian measures and then they're abusing it. I'll leave it at that. Menika, thank you very much.
Thank you very much, Mr. Vadvan. Next discussion, I will come to you first. Last word to Nani Nair. Don't feel compelled, Ms. Nair, to defend the department in any fashion or to respond to the many issues that have been brought up. Like you said at the very beginning, paying taxes is a little bit like visiting the dentist. Probably you're right. My question to you is this: can we make it less painful?
Menika, I would say that, technology will help in making this whole process of tax payment and tax assessment less painful. Because if you see that we are now going into a regime where from end to end, we do not want you to enter our offices. Because there was always this allegation that the tax administrator was not polite, he was not honest, it was harassment of the taxpayer. So we have tried to cut the interface between the department and the taxpayer. The very fact that Mr. Vadva said you said that people are trying to find out who is the officer for faceless assessment, it shows that it is the taxpayer who is, trying to reach out to settle his affairs because he feels that, his affairs are not correct. And that is the mindset we need to eliminate in the process. And how do you eliminate this tax evasion and, trying to get a benefit from the department is that you collect information. One. So when I have information, I can then tell you that, yes, we have all this information and you have to file your return accordingly. Secondly, we need to have very clear laws. The drafting and the way it is worded should not leave loopholes. There should be participation with the stakeholders. So, whenever we have a law, we should try and have a stakeholder participation. And if we cannot have it with the law, at least with the subordinate legislation, with the rules, we should have that participation so that we make strong laws which can be implemented without pain or without any divergent views like this. Thirdly, I would say that, in India, we have so many decisions, on the same point. Different high courts have taken different views, different tribunals take the different view. So as a result, it makes the administration of tax law very comprehensive. We should, as CVDT, try to see that we should get clarity at the outset before it has become a problem. So a proactive approach on establishing that this is our viewpoint, this is the law we follow, rather than waiting for Supreme Court to give a finding, that approach has to be changed. We need to be more proactive in coming to a decision that this is our legal position on this point. After that, I would say that taxpayers, we should have clear timelines for resolution of disputes, of grievances, so that, we can, through technology, ensure that it is, we are meeting the timelines. And lastly, I think, the book had two suggestions, which I always felt would be a good suggestion to do. One was the Dutch model of horizontal monitoring, which Mukesh would know because it says that even before a corporate has filed a return, they have dialogue with the tax department on issues which are of debatable, so that they reach consensus. So when the return is filed, there is less litigation. The other is the US model of a tax advocatory service, where there is a body backed by statute which should look into grievances of taxpayers, should look into grievances of a class of taxpayers which arise of any law, and they should be able to talk, have a dialogue with CBDT and find resolution. If it has a statutory backing, it is a body established by a parliamentary act, it would always be more effective than ombudsman, which is what Mukesh said in the beginning, was a parking lot for retired officers. So these, I believe in initiatives. Charter is just an aspiration. We should have initiatives to ensure that we meet those aspirations. Thank you.
Thank you very much, ma'am. 20 years ago, when I started covering tax, I didn't think we'd have such a forceful conversation on rights of taxpayers. That in itself is progress. Thank you very much to this esteemed panel for all of your thoughts. I'm sorry if everyone didn't get as much time, but time is always short. I urge all those outside and external audience to read the book. It's got an excellent Nani Palkiwala quote to begin with that goes to the very heart of how painful taxation can be for all people involved. Kingship, Mr. Bhutani, thank you very much. And I'll hand it over now to the SKOCH group and the organizers of this panel discussion.
Thank you very much for taking the time out to join us this evening. I think it would be a great disservice to the audience who sent in some questions. Ms. Doshi, I've messaged them to you on private chat over Zoom in case you
chat. Would you like me to take them right now?
Yes, please go ahead. We're out of time, but that's fine. I think it will be.
Okay, I'm really sorry. I didn't mean to exceed everyone's time. So
no, this is excellent. Thank you.
Okay, the first question, let me take it to Mr. Bhutani. It is difficult to analyze taxpayer rights under current dynamic times. Do you think there is need for an interdisciplinary approach that factors in interaction with cross-border investment laws, trade laws, and public international law? The gist of the question, Mr. Bhutani, being, do tax laws need to talk to other laws for this to be a more cohesive administration?
Menaka, before Mukesh Bhai starts, you should excuse me. I have other matters tomorrow on the call.
Question for you as well, sir. Should I bring it to you right now?
Yeah, let me answer that and then take leave.
Mr. Bhutani, keep that question in your mind. Let me take the question to Mr. Venkatraman. Faceless assessments introduced last year are an illustration where, despite creating procedural ease for taxpayers, there were several writ petitions filed in different high courts on alleged violations of principles of natural justice. Could you comment on it, please, sir?
Yeah, we can comment on it. See, this is one way. This will help the assessee community to understand. Even though initially there was a mistake, we redeemed it at the quickest possible time. That's the answer. In the sense, when writ petitions were filed and one of the transfer petitions came before the Supreme Court, we requested the Supreme Court not to pass orders, and we said we will amend the rule and bring the rule before the court. We gave an assurance before the court, went back to the drawing room, and the ministry worked immediately on that. We brought the rules amended, showed it to the court, and that this is what we will follow. So this is something to say. I'm thankful to that friend who has suggested this question. This is something which meets with the requirement of your code. We have acted very fast, and the ministry acted very fast, I should say. And the court was very happy that the response was on quick possible time. So there are ways. See, if there is mutual trust, many things can be resolved. Today's resolution before the Supreme Court was on mutual trust. I started with it and let me end with it. Both sides agreed that it's too far-fetched to take it backwards under the old law. Nor it is happy and fanciful to say that you have to issue 90,000 notices, we will ignore all them as no notices in the IF law. Both agreed to a converging point. And on convergence, this order is yet to be released. So therefore, I cannot say this is an order. But at least the inclination of the court appears to be that both sides converge. It is possible to achieve a lot if both can work together. Namaste. Thanks a lot, Mukesh Bhai and Kinshu and Mr. Samir and others.
Thank you, Venkat sir.
And it's such a nice opportunity to be with the presence of very, very eminent people in this panel. It was a big learning for me too in the process. Namaste. Thank you.
Thank you very much, Mr. Venkataraman. And you're leaving on a high note, as you pointed out, in mentioning the changes that have taken place with faceless assessment and keeping taxpayer easy.
The code is coming into full force. Don't worry. Bye. Bye.
Mr. Bhutani, I parked a question with you. Would you like to go back to that?
Yes, the answer is a resounding yes. In fact, one of the things, one of the primary reasons why we need a new tax code is because the tax code should first talk to the Constitution, because there are many articles in the Constitution scattered all over which talk about tax as a subject, including the fundamental rights, though Venkat sir disagreed with me that we can't bring taxpayer rights on par with fundamental rights. I hope in my lifetime the day comes when the Supreme Court says that it is a fundamental right. Second, the tax code should, in my view, talk to other tax codes, which is now, fortunately, only the indirect tax code. Thirdly, it should talk to fiscal laws. And fourth, more importantly, it should talk to public international law. And let me illustrate that, what I meant by saying public international law. In March 2021, the Supreme Court settled a dispute which has been going on for over 2 decades, where IBM and GE were the lead case. And the simple issue before the Supreme Court was that by amending a retrospective law in 2012, did you override the obligations that the Union of India assumed by signing a double tax treaty, which is also an empowered right under the Constitution? And the Supreme Court said, no, it's not possible. 17 double tax treaties were overridden by one 2012 amendment to which the Supreme Court said no, that the treaty law will prevail over the domestic law. So that's a classic example how your income tax code and the changes can override what is established practice under the public international law. So my ask would be, Menaka, public international law, fiscal laws, other direct tax laws, and constitution law. The tax code should talk to all these three classes of laws, in my view.
Okay, great. And Mr. Bhutani, if I can say so, tongue firmly in cheek, before you ask for rights, please deliver on duties.
No doubt about it.
Having the mood in the country, right? I have a question for Ms. Rani Nair. Ms. Nair, this goes to, this is, I think, the several crore taxpayers in this country are asking this question. Since tax payments have traditionally been perceived as aversive and loss-making, is there a need for the government to strategize and repackage taxes and tax laws where taxpayers may be made to perceive the payment of taxes differently? In short, can you make this not just a less painful exercise, but almost a joyful exercise? Is there any scope of that happening?
You know, it depends on, we can provide you the platform to make tax compliance easy. Whether you feel that paying taxes is a painful exercise or a joyful exercise depends on your own mindset. You know, look at it as a reduction in your earnings, or you look at it as your contribution to nation.
Okay, all right. Let me put that question to Mr. Wadhwa as well quickly. Sir, quick answer. Do you think there's anything that
I was dying to respond to this. So how does it become a joyful exercise? You know, ever since independence, you've tried all kinds of amendments, laws, draconian, easy, but somehow it hasn't passed muster. You have a very handful of assessees. And why do people get troubled? Troubled while paying taxes? Because the burden falls on a few and not on a very large number. But if the burden is broad-based, your taxes can come down. So I have a suggestion. I mean, it may sound vague to you right now, but I do have one. I say, abolish income tax, have transaction tax. I'll give you an example. Ajay Wadhwa is an advocate and I give an undertaking whenever I deposit my fee in a bank. And being an advocate, 8% is taxed at source by the bank. You have a trader who makes 1% or maybe 3% as income, tax him at 5% on his receipts. Tax the receipt side. In that manner, have a graded system of collecting tax from different kinds of assessees. I would even go to the extent of saying, just to get them in the tax net, tax select agriculturists at 0.01% of their receipt, which is not even significant. This gets connected to your GDP. And everybody starts to contribute to the exchequer. Another thing, Meenakshi, is very important. Once the money comes into my pocket, then to pay as an advance tax is a very difficult job. Very, very difficult to get money out. But whenever the money comes after the deduction, you don't even bother about it. If 95 rupees comes to me after tax deduction, I don't bother about the 5.
Mr. Wadhwa, in the interest of several crore taxpayers, I should pause you here itself. Please.
You know, I'm paying 47%. I'm paying 47% in taxes on my, because I'm an individual, I have to pay the highest rate.
Not convert advance tax as part of TDS. I think I'm not sure everyone will look upon it as kindly, but I get the spirit of your suggestions. I can't leave a comment that suggests abolish income tax unresponded to. The journalist in me will not be able to sleep well tonight. I'm going to put the task of the response with Mr. Subhash Garg on this. Mr. Garg, last response to you on this panel discussion. We have asked all the questions that the audience has wanted to answer. So I will leave this one to you.
I think the suggestion of Mr. Wadhwa can be applied to what is the indirect tax, not the direct tax. Direct tax is a very different purpose. So 8 crore businesses, which in India are smaller than the bigger ones, I think all of them should be brought to the GST network. In fact, the system can be designed where those who earn very small amount of incomes, they may not pay tax, they may file returns so that every transaction comes into the system. But income tax has a different purpose. Income tax is the equalization of the incomes between very rich and the very poor. That's a redistribution function of the government. And that is what that function is serviced. Whoever earns more has to pay more. Whoever earns less has to pay less. In fact, negative income tax in the form of subsidies, etc., is recognized as a legitimate state function. So I don't think income tax can be abolished by substituting this with some transaction tax. That idea has come from Arthvevastha, or then there's that organization. I don't think that's a great idea at all. The function of the indirect tax, the VAT tax, the income tax, and the wealth tax are different. We, in fact, should have wealth tax also to sort of redistribute the wealth in the economy. So all the 3 taxes have their functions, and that is what need to be done. Okay. I'm going to leave it there. Thank you very much. Before we abolish income tax or expand wealth tax, I think the remit of our conversation is done. The book is excellent. Thank you very much, Mr. Bhutani and Kingshuk, for giving us so many different topics to talk about this evening. And it's back to the organizers at SKOCH. Thank you.
Thank you.
Thank you very much for spending this evening with us.
Thank you very much.
Thank you.
Bye-bye. Thank you very much.
Bye-bye.
Good night.
Thank you. Bye-bye.